Alright, as I learn Wisconsin law, I'm trying to, just at the basic level of a discovery request, I'm trying to figure out between using criminal or civil procedure, because there's only two. There's no discovery statutes anywhere. Well, see, it's confusing. It's like all the Wisconsin statutes are from 0 to, I don't know, 1,000. It's just a lot of them, and they're all packed together as a list of Wisconsin statutes, and then within that list there's sections. There's section for criminal, sections for civil. There's all kinds of sections. There's the forfeiture law, but I mean, the forfeiture law isn't exactly law in itself because it doesn't cover discovery. So you look at discovery for either criminal or civil, and apparently forfeiture law hovers in between criminal and civil. So which set of laws do you choose for discovery? And I mean, it makes sense to me that I would use the criminal part because they're trying to punish a wrongdoing, and that's criminal to me. I don't know how that could be civil and follow along with along the lines of a civil discovery request as a defendant. To be denied discovery it just sounds preposterous to me. As far as I know, everybody in every state, you have a right to discovery in every state, and in Wisconsin it's like Wisconsin's a state where I kind of question if I have a right to discovery. And the way they have it worded is the initial part of it. You don't exactly have a right, but if it goes to trial, then suddenly it becomes a right. And that seems to be a lot of the case with Wisconsin. Is they'll like initially make it look like a simple procedure, but then when it gets rolling along, if you don't pay your money, then they get a lot worse. Like Wisconsin has got around the free lawyer aspect by just saying you only owe money, but then if you don't pay the money, you face 6 months in jail. So they put a wall in between you and the lawyer, and I would just outright declare I refuse to pay any money. Right in court, right on record, just outright. And then, yeah, the warning would be, if you don't pay, you get 6 months in jail. And then, upon hearing that, then that should trigger a free lawyer, okay? So, as part of their process, it seems like you have to make certain declarations. It seems like they force you to make arguments in favor of getting discovery. It seems like you have to make arguments in favor of getting a free lawyer as well. Even the public defender says you don't get a free lawyer, and it's in this part of the process. But the later part of the process is jail time, and that's when they're collecting. That's when the judgment has already been passed. See, what they want to do is get to that judgment, and in the most efficient way for the state as possible. So they take out all the jail issues at the initial phase, and then the second phase, why do you need a lawyer? You're not facing trial. You owe money if you're found guilty. So they skip out on the lawyer by by putting these roadblocks. So I mean, I think my best strategy is just to simply say I refuse to pay any money if I lose, and then see what the court has to say about that. All right. And I assume that they're probably going to want to dance a fine line and say, oh, we'll get to that when we get to that type of thing, and not actually tell me what the penalty is. Maybe I could push it a little further and say, if I refuse to pay any monies if I'm found guilty, what is the punishment for that? And then we'll see what the court has to say about that. All right. If there's any mention of jail time, in which, I mean, in the law it says there is, then that's what they should mention. All right. I can mention it too, that it says it in the law. You're facing 6 months if you refuse to pay. And I declare that I refuse to pay. So this is only in the initial phase for discovery right now, but I'm before discovery and before the first hearing for both my cases in Milwaukee and Over-Detained County. So I mean, I can create arguments, but I want to see the evidence first. I'm holding off on writing a motion to dismiss, all right, and putting my arguments, because I just read in the law that it says if you're in prison and you write a motion to dismiss, they deny you your discovery. Don't get ahead of yourself. You wanna just keep it in order, okay? And this is what I've learned in other states, and in Wisconsin they really twist you around if you get out of step with the process. So I'm just focusing on discovery, and I want to write a second discovery to cover my basis for the forfeiture law. I had ChatGPT. I said, ChatGPT, write me a discovery request based on the set of statutes for the forfeiture law, which there's quite a lot going on in that forfeiture law. I deleted things I didn't feel it was appropriate, like the government taking property, like taking actual land or something. I got rid of that, or the failure to pay. If you don't pay, the rules with that. I got rid of all that. I just wanted to focus on stuff that was relevant. The only thing that's relevant to me is for when you don't pay, it's a 6 months in jail thing. And then ChatGPT just instantly came up with a set of discovery requests within just the forfeiture law, and it's talking about like the records that are written as part of the forfeiture law that I'm requesting as part of my discovery. I didn't request this forfeiture. I don't know, like the paperwork involved for it, how the judge arrives at the conclusion for forfeiture and stuff. Just it's asking questions within the forfeiture law itself, a discovery within the forfeiture. I think it's interesting, and I want to submit that as well as my discovery, because yeah, I mean, I want body cams, I want police reports, witness statements, all that. But since this is forfeiture too, there's the fine process, which is a little bit more it's more just comprehensive on its own. So it's a separate discovery request in a way. Forfeiture law makes its own separate discovery request as far as what I'm reading that ChatGPT presented. But yeah, I mean, I'm looking at my defenses. I mean, there's defenses to why my shoes are outside my car, why it's legal to have some screens on your car. There's people who have mentioned the rule of lenity, which is asking for the lower approval for a defense. just, yeah, the ambiguity, lack of clear prohibition, officers' interpretation. There's also the right to travel. Yeah, I mean, from state to state or within the state, you have a right to travel, but also, I mean, you got to stop places too. And as a traveler, I don't know what's going on in all the parks. I had no idea they would enforce some kind of camping ordinance without any warning. This is, I mean, am I blind? I got out of my car when I stopped there right at the start, got my walking stick, doing my stretches, walking around the parking lot, looking at the swimming lake. They have bathrooms. I checked out the little billboard with the signs. I saw nothing about no camping. And then I get this cop that springs upon me the no camping issue, and without warning, I get a ticket. And at least with trespassing, you'll get a warning before they give you a ticket. And they don't do that with camping. Somehow, you know, once again, they're finding ways to skip around steps in their process, and it's hurting the community. It causes a chilling effect on visiting Outagamie County parks. In fact, any Wisconsin park. If Outagamie could do it, any Wisconsin park can do it. I mean, I've already avoided state parks because they charge money. But if you go to like the natural preserves, the natural area, the state natural areas, those are free. But county parks, I have to admit, I've seen some county parks that want to charge money, and I avoid those. You don't find out until you get there. All right, Google Maps don't tell you, and sometimes even when you go to the website, often if you want to just check out the websites, they don't tell you. You have to show up, and then suddenly, you know, you drive 10, 15, 20 miles out of your way to go to this county park to find out that they want to charge money when you're there. They don't want to give you a warning ahead of time. And there's just these surprises, and that's fine. You know, I've turned around and went and looked for somewhere else to hang out when I see a cost. But I mean, there's nothing at Plamen Park. All right, there's no warnings about camping. They didn't say this is where you camp. They didn't give it. There's no time limit. A lot of parks will give a time limit for how long you can be parked. I've seen that. There's just nothing. There's just a cop who surprises you with a ticket. All right, and that's and I argue for obvious notification. All right, a clear notification that gives a fair warning about this issue of camping. Okay, they don't do that, and so that's a factor. I was calling it entrapment before, but I went to ChatGPT and asked what's an alternative to entrapment, and is getting a fair notice, a fair warning, fair notification to know what their problem is. So there's defenses, but I'm not at that. You know, like trespassing. That is trespassing similar to camping? Not quite, but you know, there's along the lines. If you want to maintain a consistency with warnings and punishments and fines and jail time. But I'm not at that level yet. I'm not going to submit any motion to suppress evidence. I'm not going to submit anything like that yet. I want to see the evidence first. So I'm just focusing on the discovery. I'm focusing on bill of particulars. I'm right now, I'm in a learning phase. I'm trying to learn before I can turn around and expel. And it's not just learn about the details of my crime. I'm trying to learn Wisconsin law and the forfeiture law. And to me right now, it makes sense to just stick with the type of discovery that's probably more on the criminal nature with punishment. So there's that. I'm looking at the civil just to be prepared, because a lot of people keep insisting there's the civil aspect that the judges are considering, and I'm like, okay, I'd like to depose the cop. Let me depose Deputy Oligny. And instantly I have deposition questions, just based on the law and our transcript of our conversation. I just put those into ChatGPT and said, write me a deposition, and it looks good to me. So then I asked for what are the steps for deposition, and based on the deposition law, the statutes and the Wisconsin statutes for deposition, I plugged that into ChatGPT and then asked, what are the steps for deposition, and I got that. I have to give some good reasons why I want a deposition, so ChatGPT can take care of that for me. So there's steps involved. Deposition is a little further out. I'm in a rush, so I don't want to be stuck in this city, in this area forever. So I got my court date pushed up, so I got a week before my first hearing, over a week, and I'm preparing by trying to gather the evidence, and then just take it one step at a time here.